Foreign money. Two words that can either build a school or start a storm. Because money rarely comes without expectations. If someone sitting thousands of kilometers away is funding an organization inside India, who decides whether it's charity or influence? That question lies at the heart of one of India's most controversial laws, the Foreign Contribution Regulations Act. And in 2026, that law is back in spotlight. FCRA lets NGOs and other similar organizations receive foreign funding for functioning. But let's rewind a little because this story begins in 1976. India was under the emergency. The Indira Gandhi government believed foreign governments and intelligence agencies could influence Indian politics through money by fueling protests to overthrow an elected government. The phrase back then was foreign hand. Now, whether those fears were exaggerated or justified is still debated. But the solution was simple. If foreign money is entering India, the government wants to know who's sending it, who's receiving it, and what exactly is it being used for. That's how the FCRA was born. Now, who does FCRA apply to? Mostly NGOs, charitable trusts, educational institutions, religious organizations, think tanks, universities, basically anyone receiving donations from abroad. Some people, however, were kept completely out of bounds, like political parties, election candidates, judges, government servants, media, journalists. They would not qualify for foreign funding because the idea was simple. Public institutions shouldn't be financially dependent on foreign interests. But by 2010, the government realized the original law had serious loopholes. You see, once an NGO got an FCRA license, it practically lasted forever, and the license did not have to be renewed. Monitoring was weak. Renewals, like I just mentioned, weren't mandatory. And in several cases, funds meant for welfare allegedly ended up being used for completely different administrative purposes. So Parliament scrapped the old law and replaced it with a much stricter version. The new 2010 Act introduced one major idea: trust but verify. Every registration would now be valid for only 5 years. NGOs would have to seek renewal. The government could inspect how foreign money was actually being spent, and the renewal would depend on that inspection, and administrative expenses were capped. So donors couldn't claim to be funding schools while most of the money disappeared into salaries and office expenses. Then came 2020. And this was perhaps the biggest overhaul yet. The government argued that foreign funds were getting harder and harder to trace. So it tightened the screws. NGOs with FCRA licenses could no longer transfer foreign donations to another NGO with the same FCRA license, as diversion of foreign funds could be misused. Every FCRA organization had to receive foreign fund through a designated SBI Parliamentary Street branch only in Delhi. Administrative spending was further reduced from 50% to 20%, and key office bearers had to provide Aadhaar for identification. The government now was moving towards complete transparency with this amendment. But you see, NGOs weren't exactly happy with such large levels of restrictions, so they moved the Supreme Court. Noel Harper versus Union of India brought in a legal challenge. Several NGOs argued before the Supreme Court that these 2020 amendments crippled their ability to function. The court had to answer an important constitutional question. Does an NGO have a fundamental right to receive foreign funding? The Supreme Court's answer was no. You certainly have a fundamental right to form an association under Article 19, but receiving foreign money is not a fundamental right. It is a statutory privilege, and Parliament can regulate that privilege in the interest of India's sovereignty and security. That judgment became the constitutional backbone of today's FCRA regime. But here's where things become politically fascinating. For years, the spotlight was only on NGOs receiving foreign money. But 2014 changed everything. In 2014, the conversation shifted to India's two biggest political parties. The Delhi High Court held that both the BJP and the Congress had violated the FCRA by accepting donations from subsidiaries of the UK-based mining giant Vedanta, which at the time qualified as a foreign source. The court directed the central government and the Election Commission of India to take action. But then the Parliament changed the law. First in 2016 and then in 2018. Through the Finance Act passed as Money Bill, which meant the Rajya Sabha had only a limited role to play. The amendments redefined what counted as foreign source, allowing Indian subsidiaries of foreign companies to donate to political parties, which was earlier prohibited. And here's the crucial part. Normally, when Parliament changes a law, it applies prospectively, meaning it affects future actions, not the past. This amendment did it. It was made retrospective, dating back to 1976, the year the original FCRA came into force. In effect, donations that may have been illegal under the old law were treated as legal under the amended one. This gave a legal clean slate to political parties. Fast forward to 2026. And this is where many people get confused. There are two different developments. The FCRA Amendment Bill 2026, introduced in March of this year, is still a legislative proposal, meaning it can be debated in the Parliament. But the FCRA Rules 2026, notified by the Ministry of Home Affairs on 22nd June, are already the law of the land. And these rules are far more detailed than before. The rules say NGOs can no longer simply write education or social work while seeking foreign funds. They have to specify the exact activity they intend to undertake, choose from a government prescribed list, and even declare the specific state or union territories where the money will be spent. The government has also expanded who counts as a key functionary of a FCA qualifying NGO receiving funds. The government has made disclosure requirements stricter and introduced clearer restrictions on political campaigning, ideological activities, and religious conversion-oriented work funded through foreign donations. In short, foreign funding is no longer just about who receives the money. It's also about where it goes and exactly what it pays for. For instance, an NGO may receive foreign funds in Delhi, but those funds could eventually be rerouted to conflict-prone regions like Manipur or Chhattisgarh for funding malicious activities. Government agencies have repeatedly argued that foreign money has in some cases been diverted towards activities affecting internal security, communal harmony, or public order. Officials often cite investigations into the Kundankulam nuclear protests, where some NGOs were accused of diverting foreign funds meant for welfare towards prolonged anti-protest agitations. In 2015, Greenpeace India's FCRA registration was cancelled after the government alleged that foreign funding was being used to obstruct strategic coal mining projects, which could bring in business. More recently, agencies have pointed to investigations involving alleged Maoist financing networks in Chhattisgarh, including cases involving suspicious cash withdrawals and foreign-linked funding channels. The FCRA has never prohibited religious charities from receiving foreign donations for genuine welfare work. Running schools, hospitals, orphanages, or places of worship is perfectly legal. What it increasingly targets is proselytization financed through foreign money. Under the June 2026 rules, religious activities remain permissible, but using foreign funds for conversion-oriented work or inducement-based proselytization is explicitly prohibited. Why? Because investigative agencies say that they have repeatedly encountered cases where charitable work and religious outreach allegedly crossed into coercion or inducement. Take the Changur Baba case. Investigators have alleged that an organized Islamic conversion racket offered higher payments targeted at converting women from Hindu Brahmin families. Those allegations are now a part of ongoing criminal proceedings. Or consider the TCS Nashik case, where investigators alleged that vulnerable women were pressured into adopting Islamic practices under the guise of counseling and social support. That matter too remains under investigation. Several states, including Uttar Pradesh, Madhya Pradesh, and Gujarat, have enacted freedom of religion laws that criminalize conversions carried out through force, fraud, under influence, or allurement, reflecting a broader policy concern beyond the FCRA itself. The debate has also intersected with the politically charged issue, often referred to as love jihad. While the term itself remains disputed and is not recognized as a standalone legal offense, investigative agencies in some cases have examined allegations of organized networks using relationships as a means of facilitating unlawful religious conversions. These organized networks receive funding for such activities. The government holds that if foreign money is being channeled into organizations that are later found to be financing coercive conversions, extremist recruitment, or organized influence operations, then that is no longer simply charity. It becomes a question of public order, communal harmony, and national security. That's precisely why the 2026 rules demand for greater transparency. But critics see another side. They argue these tighter regulations disproportionately affect Christian charities, missionary organizations, and some madrasas that depend on foreign donations for hospitals, schools, and welfare work. Some also fear that the proposed 2026 amendment bill, which allows the government to appoint an authority to manage assets of organizations that lose their FCRA registration, could hand the centre excessive control over civil society institutions. This criticism didn't just stop at India's borders. US Congressman Chris Smith warned that the proposed law could hurt American-funded charities, hospitals, and educational institutions operating in India. He even urged US State Secretary Marco Rubio to take up the issue with New Delhi. He paid us a visit. India's response was blunt. New Delhi reminded Washington that every sovereign nation has the right to regulate foreign money entering its borders, especially when questions of national security arise. And then came India's counterpunch. The government pointed out that the United States itself has the Foreign Agents Registration Act, or FARA, requiring entities working on behalf of foreign interests to disclose their funding and activities. Similarly, UK has its Foreign Influence Registration Scheme. Australia has its own foreign influence transparency laws. Canada has tightened oversight too. So if Western democracies can monitor foreign influence in the name of protecting their national interests, why should India be denied the same right? The government's message was unmistakable. Don't lecture India on regulating foreign funding when you're doing exactly the same at home. New Delhi also rejected allegations that the law specifically targets Christian organizations. Its position is that rules apply equally to every NGO, regardless of religion, and are aimed not at genuine charity or humanitarian work, but at preventing foreign funds from being diverted towards political lobbying, unlawful religious conversions, extremist networks, or activity that threaten public order. Let's be clear, no country likes foreign interference in its internal affairs. Not the United States, not the United Kingdom, not Australia, and certainly not India. The same countries questioning India's FCRA have built elaborate legal frameworks of their own to monitor foreign influence in politics, media, and civil society. So when India says it wants transparency over foreign funding, it isn't inventing a new principle. It's exercising a sovereign right that every major democracy already claims for itself. Yes, NGOs perform extraordinary work. They build schools, run hospitals, provide disaster relief, and genuine humanitarian work must never become collateral damage. But neither should national security. Because if even a fraction of foreign money is diverted to finance coercive religious conversions, extremist networks, separatist movements, or campaigns designed to destabilize the elected government, then the cost is paid not in dollars, but in India's social fabric. Regulating foreign money is not isolationism. It's statecraft. And in an era where influence travels faster than armies, following the money may well be the first line of defense. This is Shivangi Mukherjee for India Abroad.